Welcome to the Tech Law Podcast, where we explore legal issues affecting technology companies, from startups to the giants. If it's tech and it's legal, we talk about it here. The show is presented by Pillar Legal. We help tech leaders protect their companies so they can focus on innovation and growth. Today, we have a special treat for you, a video that was recorded at a Harvard Business School Association alumni event at the Bootcamp for angel investors. This is an online event. It's held every fall. If you happen to be an HBS alumni, I encourage you to check it out. Big shout out to Alex McCulloch, who helps to organize the annual event, and she also has me back year after year. Thank you for that. You'll see her in the video, both at the intro and also at the Q&A section. The content, it's an overview of SAFE's Simple Agreement for Future Equity, the Y Combinator standard document, which we love, as the simplest, easiest, fastest, most cost-effective way to get funds into a startup. We have some numerical examples of conversions and how that works, and also talk about one problem with the safes and different ways to address that. I hope this is useful to both founders and also to angel investors. Thanks a bunch for listening, and enjoy.
We're going to move to our session on about a safe offering. And again, we're going to continue using this example company in our head that we're calling Mojo Dojo Inc. And I am really pleased to introduce everyone to Greg Pilarowski. Greg is an alum of Harvard Law School, and he is the founder of Pillar Legal, a boutique international law firm with offices in the San Francisco Bay Area and in Shanghai. He has extensive experience representing technology companies, venture capital firms, and startups. Prior to founding Pillar Legal, Greg was general counsel for Shanda, a leading online game company. And before that, he was with Sullivan & Cromwell, an American multinational firm. So on that note, Greg is just sharing his screen. If he goes into presentation mode, we are going to welcome you, Greg. So thank you so much.
Wonderful to be here and to get a chance to talk with everybody from the other side of the Charles River. Today, we'll go through the Simple Agreement for Future Equity, SAFEs. I'm a huge fan of SAFEs, and it wasn't until starting to interact with this group that I learned that there's some people who don't like the SAFE. So just disclosing my prejudice up front, and looking forward to interacting with some folks on pros and cons of the SAFE. The goals for this talk, at the end of it, I'm hoping everybody knows what a SAFE is, how it works, how to use it, some of the pros and cons, and if we have time, I'd like to get to one bad thing about SAFEs that happened with the 2018 change that I'll recommend folks to make an adjustment to if you end up using a SAFE. The SAFE, it was first introduced in 2013 by Y Combinator, a really well-known accelerator out here on the West Coast where I am, San Francisco Bay Area. A lot of the companies that they have backed are household names today: Airbnb, DoorDash, Dropbox, Coinbase, Twitch, Reddit. When the instrument came out, it was considered, and today is still considered, a very founder-friendly kind of document. As we've talked about in some of the other sessions, there's three main ways to get funds into an early stage company. One is through the equity financing that you just had a walkthrough on the term sheet on. There, it's just a lot of legal documents. The NVCA forms are very long, complicated. The Series Seed forms, less so, but nonetheless, a lot of pages. And of course, you have to agree on a valuation. For convertible notes, those can postpone the valuation discussion to some extent, although with valuation caps, it sometimes leaks back in. There's less legal documents than the equity financing, so lower cost there. But one of the unfortunate things about the convertible notes is that everybody has their own form. and the conversion mechanisms, they are fairly complicated. And so it does take some time to look through them and make sure that they work the way that you expect them to if it's a document you haven't seen before. What's wonderful about safes is that they're standardized. The great contribution that Y Combinator did is because of their position in the market and being so well recognized. By releasing the safe and pushing it to all of their investee companies, it became a bit of a standard. It's open source, it's available on their website, and it's that standardization that I think is the great value. There are a couple different forms of the safe, and you can see down in the bottom left-hand corner what the document page looks like at the YC website. There's a discount only, a valuation cap only, and an MFN only. MFN only, I've never seen this used. It doesn't have a discount or a cap. It just has this right to change into a future safe if a future safe is issued with more favorable terms. There used to be one that was a discount and valuation cap. Y Combinator took that away a couple years ago, thinking that was a bit too friendly towards the investors. For the basic rights in the safe, the key one is the right to convert into equity in the next equity financing. So that's a priced round in the future. The safe will convert into equity at that next equity financing, generally as preferred stock. There are some other rights that you have under the safe that are listed here and we'll talk about. They don't tend to come up as much. So the key right is really this conversion into stock in the next equity financing. And we'll talk about that one in a little bit more detail because that's the more common outcome. There are some basic defined terms that are used in the safe and which we'll use in this discussion as well, the same exact terms from the safe. Purchase amount is the amount that the investor puts in. Discount, that's the discount on the price that you get in the conversion in the next equity financing round. Valuation cap, that's also a cap that's used for conversion in the next financing round, again, depending whether you have a discount or a valuation cap safe. Equity financing, that is that next equity financing round where the safe converts. And then the safe price, that's the effective price per share that the safe investor is ultimately paying. And that's figured out at the time of the conversion as opposed to the time of the investment. Greatest thing about the safe, it is only 7 pages long. There is no safe term sheet because the safe itself is teeny tiny. And you'll notice that 2 of these pages don't have that much text on it. So it's really just a 5-page document. And it is just the fastest way, most efficient way to get funds into an early stage company. You really don't need lawyers to do this. And so maybe some lawyers hate it for that reason, but it's wonderful for early stage companies because it's so cost effective and can be done so quickly. So when you use the safe, I think probably one critical thing to do is to make sure that the document you're looking at is the same as the one on the Y Combinator website. That's pretty easy to do. If you know how to use the compare version in Word, you can just look at what's been sent to you and download the one from the Y Combinator website, whether it's discount or valuation cap, run a compare version, see what the changes are. Hopefully there's none. And if that's the case, then you're using an instrument that's been used thousands of times, tens of thousands of times. And so you don't have to dig through all the details and make sure that this document works. It works. When you're using it, how do you use the safe? There's really only 2 things that you have to decide. One is the purchase amount. So that's the amount that you're investing. And then the other one is, are you going to use a discount safe or a valuation cap safe? And then depending on the choice there, and sometimes the company will guide you in one way or the other, of course. If you use the discount safe, you need to decide what's the discount. If you use the valuation cap safe, you need to decide what's the valuation cap. For discounts, we often see a 20% discount to the price in the equity financing round in which it'll convert. Now that's expressed as 80% in the document, but the way we speak about it in English is a 20% discount, 20% off. The valuation cap, that tends to be part art, part science. You good folks on the south side of the river, I know, spend a lot of time on this one, so I'm not going to pretend to add any value there in terms of how you get to the valuation cap. What I would like to do is to talk through two examples of how the conversion works. One is for the discount only safe, and one is for the valuation cap only safe. The reason I'd like to spend a little time on this is for the safe. Really, the critical thing is how does it convert? It's that right to convert in the next equity financing round. So I think looking at an actual example can help to bring that to light. So in this first example, this is the discount only. On the left side of the screen here, we have the cap table before conversion. I did this to make the numbers really easy. Us lawyers, we like easy numbers. I know you guys are good with complicated ones. This one's simple. So 1 million shares before conversion, 90% with the founders, 10% with the ESOP. And then in our scenario, the safe holder invests, we just have one safe holder in the scenario, invests $200,000 at a 20% discount. So that discount in the document is expressed as 80%. And then the new investor invests $2 million at a $20 million pre-valuation, pre-money valuation for the company. So on the conversion, what we want to solve for is how many shares does the safe holder get? And the number of shares is the purchase amount divided by the safe price. So 200,000 divided by the safe price. The safe price in a discount only safe is equal to the price per share in that next equity financing round multiplied by the discount. So multiplied by 80%. That price per share in that next equity financing round, that's going to be equal to the pre-money valuation of the company, so that 12 million, divided by the company capitalization right before the equity financing. Now that company capitalization right before the equity financing, it's on a fully diluted basis. What does that mean? Here's where people differ a little bit, and you can see some variation. So fully diluted basis, for some folks, it might just mean the founder's stock and the ESOP, so 1 million shares. And so in that instance, you take the $12 million divided by 1 million shares. That gets you your price per share in the next equity financing round. You multiply that by 80%, and that gets you your safe price. However, some folks fully diluted, they will also include in that capitalization all of the shares that are issued to the safe holder. And so now you get into a little bit more complicated math. Over here on the left-hand side, bottom left, is the formula that you would use to solve for that. I have a spreadsheet that I can share later if you're interested. It works out to the safe holder receiving 21,000, a little over 21,000 shares. And then when we plug that math back in, it means that the company capitalization before the equity financing, it's that million plus the safe holder shares. And so for the new investor's price, you take the 12 million, the pre-money valuation, divide that by the company capitalization of a little over 1 million shares, you get to the new investor price in the equity financing round of $11.75. Multiply that by 80%, that gets you to the safe price of $9.40. And then to get to the number of safe shares, you just take that 200,000 divided by 9.40 per share, and you get that safe shares. Down on the bottom, it shows the cap table at different stages. So on the far left, it's the pre-safe conversion, what that cap table looks like. You see the founders and the ESOP in there at 90-10. Post-safe conversion, you can see the safe holder on there at about 2%. And then the next one shows what the cap table looks like after the equity financing. So after that $2 million comes into the company and you're issuing preferred stock to that new investor. So this is how it looks in conversion for a discount-only SAFE. The next example is how the conversion looks for a valuation cap-only SAFE. Now here I've taken the same numbers to make it easier to follow. So the cap table before conversion, it's similar, 90% to the founders, 10% to the ESOP. Here, the safe holder also invests $200,000, but instead of being at that discount, now we've got a post-money valuation cap of $8 million. So not a discount, this is the cap safe. The new investor is still investing $2 million at 12 million pre-money valuation. So all the numbers are the same here, except instead of a discount, we've got that valuation cap. So we're again solving for how many shares go to the safe holder on conversion. And it's the same thing. It'll be the purchase amount divided by the safe price. So that's exactly the same as for the discount. But here, the safe price is calculated differently. Here, the safe price is equal to the valuation cap. So that's the $8 million divided by the company capitalization. Now, the company capitalization here, it's a little bit different than that fully diluted capitalization in the next equity financing round, in the sense that there's not two ways to do it. There's only one way to do it, and it's defined very clearly in the SAFE itself. That company capitalization that's used in this formula, it's going to be equal to what's out there for common stock. So that's the founder's number, the whole ESOP pool, and everything that's going to be issued to the safe holder. Now, what's nice about this valuation cap only SAFE is that we know what percent every safe holder is going to hold after conversion and before the next equity financing happens. The percentage is going to be equal to the purchase amount, so that's that 200,000, divided by the post-money valuation cap, so that's 8 million. So we know that this safe holder is going to own 2.5% of the company after the safe converts, but then they'll get diluted by the new equity financing round. Because of that, it makes the math a little bit easier, in that we can say 900,000, 1 million shares plus 2.5% of the over company capitalization is going to get us to the company capitalization. And so we run the numbers on that, and we get to a little over 1 million shares for the company capitalization. Divide that by the valuation cap, get the safe price here of 7.8 per share. And so the number of shares the safe holder is going to receive, then you take that 200,000 divided by the safe price of 7.8, and that gets us again back to the safe holder conversion shares. The new investor purchase price, that's going to be post-money valuation divided by the company capitalization right before the equity financing. And that's $11.70. We get the new investor shares here. And then down in the cap tables below, we can again see what it looks like pre-safe conversion, post-safe conversion, and post-equity financing. I believe that the organizers will send you all the slides, and we can include an Excel spreadsheet that shows the calculations. These two conversion mechanisms, this is really the heart and soul of the SAFE. If you've got a discount one, it's the discount math. If you've got a valuation cap one, then it's the valuation cap math. There are a couple of other rights that you have under a safe holder, under a safe note. These are mostly closing down things that could happen or addressing things that could happen. In most instances, though, the SAFE will convert in the next equity financing round through one of those mathematical formulas. But it is possible that the company could get bought out in an M&A exit before the SAFE converts. If that happens, and an IPO is theoretically possible, but so unlikely that, but it's addressed in the document. So if there is a liquidity event before the SAFE converts, what happens to you as a SAFE holder? You'll receive the greater of your purchase amount, so what you put in, or what you would have received in that M&A exit if you had converted. Now the math on that's a little bit different, whether it's a discount only or a valuation cap. But in the M&A exit, you can solve for that, and you'll receive whatever everybody else receives. So if it's cash M&A deal where people are being paid in cash, or if it's stock of the acquiring company, you'll receive whatever others receive. The one thing that is pretty likely to happen, as most startups do fail, is a dissolution event. So the company fails, they go through bankruptcy, or if there's nothing left, they just dissolve. In that instance, what happens to you as a SAFE holder? Conceptually, you're treated the same as non-participating preferred stock. So the same as if you were a preferred stockholder. You're junior in preference to all the creditors, including convertible notes. And then you're on par with all other SAFE holders or preferred stockholders, and then you're senior to the common shareholders. In most of these instances, there's nothing really left. So if the company fails, there's not much that would get to you. But this is how the rights are set up in the SAFE document. Dividend rights. Early stage companies never pay dividends. This is addressed in the document just to close down different possibilities. So if for some reason a dividend was paid before the SAFE converted, the SAFE holders would have a right to receive their portion of that dividend as if they had converted. That conversion in the cap SAFE happens at the cap for the purpose of calculating what your right to dividends is. Under the discount, it's a little more complicated to figure out how that would happen, but generally it doesn't come up. Participation rights. So in the earlier sessions, there's been a lot of discussion about having that right to buy your pro rata amount of new equity financings. In the current version of the SAFE, that pro rata participation right is not addressed in the SAFE itself. It is addressed in a side letter. And there's a form side letter on the Y Combinator's website that can be used for that. Now, that participation right, it is only to buy your pro rata share in the equity financing in which the SAFE converts. So it's a one-time kind of deal, and then it goes away. Why is this dealt with in a side letter? Y Combinator's view on this is that whether or not folks should have participation rights is very contextually dependent. So smaller investors, generally the company wouldn't want to give that right to. Larger investors, they would. And so it depends quite a lot on negotiations. I know there has been discussions about putting more things into the side letter. It's certainly something that you could do. And I think from an angel investor's perspective, there's a couple things that might make sense, trying to be treated as a major investor in future financing rounds if you can negotiate for that. Perhaps information rights. The company is going to hate it, because from the company's perspective, having dozens and dozens of side letters out there, it's hard to track, and it can make their life complicated going forward. To make that easier for a company to accept, the way to do it, I think, would be to have some of those rights go away in the next equity financing round, but for the right to be treated as a major investor. And that can probably make it a little bit easier for a company to accept. Comparing SAFEs to those other two options, whether it's an equity financing or a convertible note, the SAFEs, you really don't have a lot of rights. You're not on the cap table. You don't have any voting rights, no information rights, none of the ROFR or co-sale rights, no drag-along rights, no governing rights, nothing. And I think that's one reason why a lot of people don't like safes. That said, when you convert in the next equity financing round, those rights come in. You'll convert into preferred stock, and you'll get those rights, again, subject to any major shareholder threshold that limits who holds the rights in the next equity financing round. Compared to a convertible note, the safe, it's equity. It's not debt. So there's no maturity date. There's no interest rate. It doesn't show up as debt on the balance sheet. This takes the pressure off the founder a little bit. You don't have to extend maturity dates on convertible notes over and over again. And I think I would argue that it recognizes the reality of angel investing, which is, it works out and you convert, or it doesn't work out, in which case there's nothing left to pay back the convertible note with anyway. Pros and cons. The greatest thing about the safe, again, is standardization, simple, short document. It is the fastest way to get money into a startup on really low cost. Cons, obviously, you don't have a lot of rights until you convert. And then there's this one thing that changed in the safe in 2018 that I want to draw to your attention so that you can be aware of it and potentially correct it if you're so inclined. So prior to 2018, the original safe in 2013, it was a pre-money cap safe. So I'm just talking about the valuation cap safe here. I'm not talking about the discount safe. And they switched it to a post-money valuation cap safe in 2018. What's pre-money? That's valuation before you put funds into the company. Post-money is that pre-money valuation plus the amount of cash that goes in. And so you might say, well, wait a minute, what's the big deal? If you invest 1 million on 4 million pre-money valuation, that's going to be exactly the same as investing 1 million on 5 million post-money valuation. You'd get 20% of the company. So what's the big deal? The big deal is in how the company capitalization is calculated under the old safe and under the new safe. Recall how we calculate the safe price in the valuation cap safe. It's equal to the valuation cap divided by the company capitalization. So the bigger that company capitalization number is, then the lower the safe price is going to be, and the more shares that you end up receiving. In the 2018 post-money valuation cap safe, what is included is all of the shares that are issued on conversion of the safe, conversion of any convertible notes, conversion on any other convertibles. So from an investor's perspective, that sounds great. Bigger company capitalization, lower safe price, more shares for me. And from a simplistic perspective, I think that's right. It's a very pro-investor change. However, there's an implication to this that's important for everybody who's using a safe to understand. And that is that once you participate in one safe round, if there's a subsequent safe round that happens, then that subsequent safe round, it doesn't dilute you as the prior safe round holder. And the dilution is taken entirely by common stock, which is often the founder. Again, sounds great, I think, from an investor's perspective. The problem is that the founder probably doesn't see this coming. And so often founders will use safes quite frequently because they're just so easy. And so you have one safe round one year, maybe you have another safe round next year, and you're stacking safes. And the amount of dilution that can happen to a founder with multiple stacked rounds of safe can come as a real big surprise to them. We have in the slides, which I think you'll have later, two potential ways to address this. with a small change to the definition of company capitalization. And you can see the actual text for both of them there. One just excludes all convertible securities. Another excludes all convertible securities that have a higher valuation cap. If you look at those two choices, we've done a couple mathematical hypotheticals. When there's not that many safes that are out there, the difference to the founders not that big. And so this continues our prior hypothetical with a $200,000 safe and adding on an $800,000 safe. In all the three different conversion scenarios, one is on the left, the current safe, and then the middle and the right are the two different modified ones that I showed in the slide above. The difference in equity percentage after conversion of just the safe, it's not that big. But if you 5x it and have 5 of those early safes, 5 of the next round of safe, once you convert everything, you can get a 9 percentage point difference for those founders. So that can come as a big surprise to a founder. And unhappy founder, then sometimes you can end up having pretty unhappy investors as well. So I encourage you to consider that change to the safe. If you don't make that change to the safe, I think it's important to ensure that that founder understands the implications, which is they're going to want to try to get to that price to equity financing round and convert the safe as quickly as they can. One last tip that I suggest to folks before we get to the Q&A period is encourage your founders to try to use the same forms. When you start mixing convertible notes and safes, or start mixing pre-money safes and post-money safes, the math starts to get complicated on that conversion. And if you've got 30 different converting instruments and they all have interlocking definitions for company capitalizations, again, I know you guys at the business school could handle it, but it's often the lawyers that are doing it. And man, it is a nightmare. So if you can stick with consistent documentation, that is much better for your good friends over at the law school.
Thank you. That was fantastic, Greg. It really went into a lot more detail than I think I've ever seen myself as far as a lawyer explaining safes to me. So thank you on that. We've got quite a few questions that have come in. So I'm just going to start with one. What are the pros and cons of using discount only versus valuation cap only safes? And the question is one more desirable to use than the other?
Great question. I think that's going to head back to you good folks running the math on it at the business school, because obviously what happens in that equity financing round is going to determine how many shares you receive. And so if there's a big delta between that valuation cap and the valuation in that financing round, then it's going to be great to have a valuation cap. But if there's not that big of a delta between your valuation cap and the valuation in that next financing round, then having the discount is going to lead to more shares for you. So you're making a bet essentially inside your larger bet of investing into an early stage company.
Okay, so the scenario, it depends on the scenario is basically what you're saying. Okay,
absolutely.
A question that came in directly to me was, if a company fails, when you were talking about the liquidation priority, if a company fails, can the safe holders end up with the IP of the company? Mm-hmm. If there are no other forms of investment vehicles other than safe holders and basically the common stock holders, can the safe holders somehow end up with the IP of the company?
Good question. So the way that it should work out is you have a buyer for whatever that IP is, and you figure out what the purchase price is, sell off the IP to that buyer, and that could be a safe holder. And then whatever's paid, then that should be distributed based on the liquidation preference. So first, dealing with all the creditors and convertible note holders, if any. Second, dealing with the safe holders and preferred stockholders, although there probably wouldn't be any preferred stockholders at that point. And last, going on to common. So if you're just taking those last assets of the company and just giving it to one safe holder, that's probably going to violate the liquidation preferences. Thus, the proper way is to sell it and then have the cash distributed based on that liquidation preference.
Okay, so it's possible, I think was the short answer. It's possible.
Oh, yes. You wanted a yes or no. Lawyers never give those kind of answers.
I know,
Yes.
I know. So let's see, we've got quite a few other questions. Assuming someone's investing early before an entrepreneur has many options, they're asking why would a safe not include an expiration date as well as an MFN clause?
Right. So if you have a maturity date on it, it's not a safe anymore. At that point, it becomes more of a convertible note, and it's debt for the company because it needs to be repaid at a certain point in time. So you're in a different category of instruments. And one of the things that's great about the safe is if you don't revise it, if you just stick with it as a standard document, that's where the real value is. If you start revising it, as I just suggested a couple minutes ago, now you can start getting into negotiations, and some of the value of that standardization is lost. Could you have an MFN clause in there? Yes, you could. You could start, you could do anything under the sun, right? So there's that MFN only safe. You could take the MFN clause from there and stick it into another safe. From the company's perspective, they're not going to like that, of course, because any subsequent safes that are issued, that could trigger an obligation to give the prior safe holders the opportunity to cherry pick on those better terms, or to convert into a note with better terms. So the beauty of the safe is the standardization and the simplicity. Can you mess around with it and negotiate different terms and put in anything? You sure could, but then you do lose some of the beauty of that simplicity and standardization when you do that.
Okay, and another question is about funding. If a startup's actually doing well in a funding round, if you ask to do any side changes to a safe, are you going to be seen as difficult and shut out of the round? Have you seen that happen?
This depends on personalities, but sure, that's definitely possible. I, for one, think that anybody who gives a founder money is entitled to information rights. And so I think it's entirely reasonable to make sure that any investor always has information rights. Now, that is going to come in the next equity financing round anyway. But as discussed in the earlier session, there could be major stockholder limitations on who has what rights. And so, if I was on the company side, which I frequently am, if I saw a request in a side letter to be treated as a major stockholder in the future for the purpose of information rights, I would say, of course.
So you think side letters can be quite beneficial, is I think what I just heard.
I think so.
So Will Moore has talked about a statistic that he has seen, he believes, from the Launchpad Venture Group, that show the average return for safe investments is only 1x, and significantly below preferred stock, and even before convertible notes. So I don't know if you have the ability to opine, but is a safe something that angel investors have to face as the way into early stage companies? If they're only returning this 1x average, why does it survive as an investment type?
Great question. Short answer, probably above my pay grade. But if I had to speculate on it, I would guess that safes are used, very early on at the highest risk component, at the highest risk stage. And so maybe that ends up leading to an overall lower return. Not sure. But I think that from my perspective, working with early stage companies, what's beautiful about it is, quite frankly, arguing against my own self-interest, you don't need lawyers for safes. And you can just get money into that company really fast, business person to business person. And I think that, reducing that burn on legal spend, it can be quite critical for companies at an early stage. And so that's a big advantage.
Okay, well, I think we are at time. So Greg, this was amazingly fantastic. So really, thank you so very much for doing this. Love to have you back. And on that note, thanks again, Greg.
The Tech Law Podcast is presented by Pillar Legal. For more information about tech, startup, and video game law, visit our website. Follow us on LinkedIn, Spotify, Apple Podcasts, or YouTube. Links are in the show notes. And now for the legal stuff. We are lawyers, after all. This podcast is for educational purposes only. The information presented in the show should not be construed as legal advice. And listening to the show does not establish an attorney-client relationship. In addition, the information presented has not been updated since the episode publication date. It may be required to be updated or customized for particular facts and circumstances. Any views expressed by guests are not necessarily the views of Pillar Legal. If you need help with any legal matter, be sure to consult an attorney. And if you don't have one, consider contacting us. This podcast episode may be considered attorney advertising under applicable law.